Welcome to the 15th episode of the Risk Settlements Podcast, Alternative Litigation Strategies, where I interview legal leaders in the litigation industry from all over the country. On this program, we discuss the latest trends and developments that are currently happening in the world of class action and other types of commercial litigation. I'm your host, Kevin Skrzowski, with the litigation consulting firm Risk Settlements, and today I am pleased to be joined by Dan Blynn, a partner in the nationally ranked advertising and marketing practice of the Washington, D.C. office of Venable. Dan, it's a pleasure to have you on the show today.
Yeah, no, the pleasure is all on my side, Kevin. Thanks for inviting me. I'm happy to.
Absolutely, not a problem. So, Dan, I know today we're going to take a dive into the Florida Telephone Solicitation Act, and more specifically, the first class-wide settlement under the FTSA. But before we get to that, let's just start by having you tell us a bit about your areas of specialization at Venable.
Yeah, sure. So my practice largely focuses on defending state and federal telemarketing class actions, especially those arising under the TCPA, the Telephone Consumer Protection Act. And for the last year and change, I've really been focusing on the Florida Telephone Solicitation Act. Aside from litigating, I also counsel clients. So the first goal is to avoid the litigation and have good compliance practices in place. But if the litigation's coming and there's sometimes not much you can do about that, given how active the plaintiff's bar is, I like to have all our defenses lined up and the strongest defense ready to go.
And speaking of litigation, over the course of the year, I know you've written several articles that appeared in JD Supra about the Alvarez versus Sunshine Life and Health Advisors case, which is also the first Florida Telephone Solicitation Act case to settle on a class-wide basis. And now we're going to take a deep dive into Alvarez, but maybe we should start just by giving the audience, or having you give the audience, just an overview of what is the FTSA and how it expanded the existing laws that were already in place in Florida, the Florida Telemarketing Act and the Florida Do Not Call Act.
Sure. So the FTSA kind of fundamentally prohibits auto-dialed and pre-recorded message telemarketing calls and text messages. And over the course of our conversation, I might just refer to calls, but it includes text messages and ringless voicemails, for those who know what those are. So the FTSA governs auto-dialers, pre-recorded messages that are placed without prior express written consent. It also governs calls and text to numbers on either the state do not call list or the seller's own internal do not call list. Those portions of the statute are fairly consistent with the federal TCPA. However, the FTSA also contains certain requirements relating to contracts entered into over the phone, such as those contracts being reduced to writing afterwards and signed by the consumer. And there are specific phrases that must appear in those written agreements, so on and so forth. Just to kind of set the stage just for a moment, Florida's actually had an auto-dialer law on the books since 1978 in one form or another. It was combined with other state telemarketing laws in 1990 to become what's now known as the FTSA. Notably, the auto-dialer language that's in the FTSA actually came into existence at least as early as 1987 when you track back the statutes. Historically, the FTSA was enforced by a Florida regulator, the Department of Agriculture and Consumer Services. There was no private right of action. And when you look at the historical enforcement of the FTSA by the regulator, one thing sticks out, and those were that the cases that were being brought were always by in-state telemarketers. So those are companies whose calls began and ended in Florida. However, last July 1st, 2021, the FTSA was amended to provide for a private right of action. And that's kind of why we're here today. There's been a sprawl of litigation filed after July 1 last year and involving in-state and out-of-state telemarketers.
Now, thank you for that history, Dan. I appreciate that. And I think that's an interesting point, because even when I'm speaking with a lot of people, including some attorneys, I don't think a lot of people understand the full history that a lot of these laws have been on the books for a long time. And while we have a lot of these state mini-TCPA statutes, and we're going to allude to a few more later in the program as well, most states, if not all, have had some kind of telemarketing laws on the books for decades. So these aren't brand new things, but they're just developments and enhancements and increased requirements. Now, you mentioned private rights of action, and there's been quite a few. So the enactment of the FTSA, I would say, has resulted in an avalanche of litigation. I know you and I had discussed this on the phone. I think you keep a tracker of this. How many cases to date? Do you have a number that have been filed?
Sure. Actually, before we got on, I looked at the most up-to-date tracker, thanks to some of my junior associates who work with me on these cases.
Of course.
We are up to 230 identified FTSA cases. I know that number is grossly under-inclusive, given the inherent limitations in searching Florida state dockets. So I would suspect the number is probably 100 or more higher. I think we're probably in the mid threes.
That's a massive amount. Correct me if I'm wrong, but you and I discussed doing this podcast maybe it was more at the beginning or the middle of the summer. And I swear the number was at 142 when we spoke.
That may well be. There's been at least one notable entrant into the FTSA space who started filing cases on his wife's behalf, his law partner's wife's behalf. Yeah. And that number is since mid-July. I mean, we're talking, it's low pleading hurdles to get into court and high statutory damages. So one form complaint is all you need. So yeah, we're up to 230.
Yeah, just churn those out. And I do believe there's like 2 plaintiffs firms that are responsible for about half, if not the majority of those filings. So we have a ton of cases here. Now let's talk about their disposition. So do you have a sense of how many of these are being resolved and dismissed on a one-off basis? And have there been many motions to dismiss that have been filed that have been ruled on and granted?
Yeah, so track both of those data points as well. So let me give you the numbers that I've got. Of the 230 or so cases that we've followed and are following, so far about 90 of those have either settled on an individual basis or been voluntarily dismissed without prejudice, meaning that in all likelihood there was no settlement.
Okay.
About all of the remaining cases are still ongoing. They're all fairly early on. The ones that are pending are largely early on in the proceedings. There have only been actually, as far as I'm aware, 6 decisions, all on motions to dismiss, including 2 decisions issued last week. And I'm happy to talk about those.
Okay.
Of the 6 dismissal decisions, only one went in favor of dismissal, in favor of the defendant. The other ones were resolved in favor of the plaintiff, which when you think about a motion to dismiss, it's really not all that unremarkable to have a motion to dismiss denied. So we've got the first one that I'm aware of was decided in March 2022. That's a case called Alvarez versus Sunshine Life and Health Advisors.
Yep.
That was in Florida State Court. Interestingly, there, the issue had nothing to do with the FTSA at all. It was all about whether or not the plaintiff had or lacked standing, simply alleging the violation of the FTSA without any attendant harm. The court said, the way I view Florida law is alleging the violation of a statute is enough for standing. Now, since then, Florida state courts have, at the appellate level, have actually rejected that. I think the briefing in that Alvarez case on the motion to dismiss probably could have hit some other more persuasive and binding decisions than it did. But nonetheless, that was the first decision. The first substantive decision on the FTSA was in a case called Chorizo versus Subway Franchise Advertising Fund.
Right.
That's Subway restaurant. And there, the court found that the FTSA doesn't violate the First Amendment. It's not void for vagueness under the Due Process Clause. And the court also said that the FTSA's auto dialer prohibition is not necessarily the same as the TCPA's auto dialer definition. So what's an auto dialer under Florida law may not well be the same as what's an auto dialer under federal law. And then since then, there have been a couple other decisions purely on First Amendment and void for vagueness grounds. And one other simply saying that a dual purpose text message. And what that is a text message that has non-transactional aims like collection messages or, hey, you've got an appointment reminder, but also has a solicitation component into it. Those are considered advertising or telemarketing messages subject to the FTSA.
Okay.
So that's kind of the landscape as far as I'm aware.
No, thanks. That's a great overview of the entire landscape of where we are to date. Sounds like we have probably 300 plus filings. 90 have been dismissed or settled on a one-off. So we have hundreds of cases to track and monitor. And I think we're going to have a lot of decisions on dispositive motions to analyze going forward. Now, you mentioned Alvarez. Mm-hmm. And of course, Alvarez was the first case that settled on a class-wide basis. From your analysis of the case in the docket, like what happened during the course of this litigation that led to a class-wide basis? Like, why do you think this case settled on a class-wide basis?
Sure. I think I have some pretty good insight into that. So the defendant took a stab at a motion to dismiss, and in that motion raised the lack of standing argument primarily, and then in kind of a cursory manner, purely to preserve the issue later on, made kind of the First Amendment void for vagueness and other, I think there was a supremacy clause, constitutional argument as well. But at oral argument, the defendant said, you know what, we're not pushing the constitutional arguments. We're purely focused on standing. After the court rejected the defendant's standing arguments. The case fairly quickly went to mediation, and there could be lots of reasons why the case settled on a class basis. My insight is that I don't know that the merits defenses, at least as far as prior express written consent goes, were very strong.
Okay.
I think that when you look at the settlement and kind of back out the figures, we're looking at a class size that's 3,000 or so range, maybe a little bit lower. And the way the settlement was structured, it's a really good deal for the defendant because the claim rate might be very low. And I'm sure we'll talk about the structure of the settlement, but it may be that the defendant buys peace, fixes its consent practices going forward, and gets out of the litigation for very little aside from attorney's fees.
I think that's very insightful. So let's talk about the settlement a bit. So first of all, let's discuss the structure. Was this a common fund or a claims made settlement?
The answer to that is yes. I say that jokingly, but the settlement's kind of an odd one. It's almost like a hybrid. The defendant in Alvarez agreed to make available a fund up to about $2.5 million that would be used to pay the benefits to the class, attorney's fees and costs, an incentive award, and the cost of settlement administration. So it's a fund that's largely determined by the claims rate, except for the fact there are going to be some fixed costs that will be awarded by the court, attorney's fees, incentive award, and the cost of claims administration that the defendant's going to have to pay. So it's a fund with essentially a reverter without calling it a reverter.
Right. And I mean, we joke like it's a common fund and a claims made, but to your point, so it's a common fund, but I believe the language is it's a common fund, but if the claims, the incentive award, the attorney's fees and costs, and notice and admin don't reach the 2.5 million, the difference shall remain with the defendant. So like you said, it's a reverter. What are your thoughts on reverters? I mean, aren't courts frowning upon them? I think even Justice Roberts from the Supreme Court wrote in one opinion that they not the most thrilled with reversionary funds.
Yeah, you're right. Certainly at the federal level, courts are pretty wary of settlements with reverters. It could wind up, let me just say could wind up effectively giving the defendant windfall for potentially egregious conduct, depending on the claims that come in. But remember, Alvarez is in Florida State Court. I don't know Florida State Court as unfriendly to reverters as federal courts are.
That's a good point. That's a great point. So discussing just settlement structures for a second. So as you're aware, in our business, we help to design claims made settlement structures, and then we couple that with class action settlement insurance to transfer the settlement risk away from defending businesses. I mean, would it have made more sense in this case just to call it a pure claims made settlement structure?
I certainly think so. I think if I were the defendant, I'd probably refer to it as a claims made, and maybe it still does, but I suspect the plaintiff prefers characterizing it as a common fund. And the reason for that is it might be easier to justify a percentage of the fund for attorney's fees. I don't know how closely Florida state courts scrutinize attorney's fees in common fund settlements, but there may be no lodestar crosscheck. I mean, in this case, the attorneys are seeking 20% or a little over $500,000 from this 2.5, we'll call it a common fund.
Sure.
And this case only lasted for 10 and a half months. It was lightly litigated, but except for the motion to dismiss, discovery was stayed pending a decision on the motion to dismiss. And so there wasn't a lot of work done. And you think about how many hours the attorneys might have spent on this case and what they're seeking. And you might have a hourly rate that is in the thousands of dollars.
So the 20% may actually be reasonable. And that lodestar probably explains why they didn't ask for the usual 25% or 33%.
It could be. But again, $511,000 is a good return for a relatively short-lived
10 months of work. Yeah, right. I agree. Now, there's another odd thing that occurred in this settlement too. The release included some language was specifically required by California law to ensure that the class member did not inadvertently waive unknown claims merely by signing a general release. Why was this included in there?
That's something I've been scratching my head about as well since I read it. But here is my suspicion is the defendant wants as broad a release as possible. And the way the FTA is drafted is it applies only to text messages or calls received within the state. Now, there's a rebuttable presumption that a call or text to a Florida area code is received within the state. But theoretically, it's possible that a California consumer or someone who lives in California that decided to take his family to Disney World for vacation, received a actionable text message from the defendant, returned to California and is part of this class. That's possible. So maybe the defendant and the plaintiff were just being conservative.
Sure. I think that's a great educated guess, but I think it just adds to some of the degrees of oddity with regard to this settlement. Anyways, let's jump into some predictions for the future. So do you think we're going to see more class-wide settlements under the FTSA?
Yeah. I mean, I think what we're looking at is kind of the TCPA litigation became the statutory cause of action for the plaintiffs bar about 10 years ago after a Supreme Court decision found that those cases could be brought in federal court. I think what we're looking at is FTSA is kind of in the early stages of where the TCPA was. I think you're going to see well-funded defendants who may not have good defenses settling and trying to buy peace of mind rather than death by 1,000 cuts. But it's important to keep in mind that this plaintiffs bar is not discriminating. It's suing mom and pop stores and retailers in Florida. I'm aware of a one location nail salon getting hit with a putative class action. Obviously, those cases can't settle on class bases because when you back out benefits, attorney's fees, and administration costs, and the defendant's ability to pay.
The business will go under. I don't think the legislative intent of the statute was ever to shutter the doors of businesses.
No, it wasn't. I mean, what's the harm in receiving a text message or a call? It's some annoyance other than statutory damages. But
I know. Yeah, that's why we often tell our clients, we said we were to use a tennis analogy. This is just a technical foot fault, but unfortunately, the statutory damages are daunting even for the largest of businesses, or you had mentioned like well-funded defendants, but still the volume of calls can add up pretty quickly. And then when you multiply that by the 500 or 1,500 under the TCPA, it's really scary. Now, I know there's some other states that have mini TCPA laws. I think they're even newer than Florida. And to your point, Florida is still very new. And so we just have we're in very much of a wait and see phase. But I think some of the other states can comment on just what's going on with litigation and settlements in Washington and Oklahoma. Are we seeing anything there yet?
So Oklahoma doesn't go into effect until November 1st.
Okay.
But it's going to be Florida Part 2. The Oklahoma statute is patterned after the Florida statute. There are a couple differences that I don't think we have time to go into here, but I do know from the plaintiffs bar, from my friends on the plaintiff side, that they are already lining up local counsel to have in place in Oklahoma.
Okay.
So I would bet that as of November 1st, we're going to start seeing cases roll in, just like we have in Florida.
So you're already seeing the movement from the plaintiffs bar, so we know what's coming. To your point, Florida Part 2. Okay, that makes sense.
Yeah, exactly. A couple other states have amended their telemarketing statutes. Washington State, New York. There's a bill that was introduced in Michigan recently to amend that statute. The Washington State and New York's amendments, they're more technical. Those statutes have been around for a while. I don't know if New York has a private cause of action. There hasn't been a lot of notable litigation out of that state under the state law. Washington has had litigation for years, and it's usually been a supplemental claim attached to a TCPA complaint. There's a bad decision for the plaintiffs in Washington State. It was a case issued about a decision issued, I think it was in 2016 in a case called Booth v. AppStack. And the Washington State statute is similar to Florida in respect that it applies only to calls and text messages received within the state. And the court there, the Western District of Washington, said, I don't know how I can figure out where someone is at the time they received a text message without undertaking an individualized inquiry on a case, on a recipient by recipient basis. Even a Washington State area code is not enough. I mean, that person might be in a different state. They might be in Oregon at a vineyard at the time of receipt. And so that text message wouldn't be actionable. What's interesting is the Booth case involved landline calls that were forwarded. And the court said, I don't know where these were actually received. They could have been forwarded out of state. So the court there decertified a Washington State telemarketing law class, and then the case proceeded. But
that is interesting.
Any state that has statutory damages, and plaintiffs' bar is creative, we're going to see a lot more litigation.
Yeah, I think we have to wait and see. There's a lot of litigation, a lot of legislation, and a lot of case law to come. I'd like to have you back on. We should do a part 2 to this show about a year from now and see what the litigation landscape looks like across the world of many TCPA laws.
No, I'd love to. We'll just have to check my blood pressure and see if it's in check.
Well, Dan, this has been a really interesting conversation. Any final comments on the future of state mini-TCPA laws, or perhaps more importantly, what advice do you give to your clients and to businesses in order to avoid potential litigation under any of these laws?
Sure. So let me start with the first part of that. My final comment on state laws is state laws are really a mess. And if you have lobbyists in the various states where the more active plaintiffs bar is, you might want to be looking at proposed amendments. And I understand that the FTSA, there are some amendments that are going to be proposed during the next legislative session. There were some that were proposed at the beginning of 2022 that would have brought the statute more in line with the TCPA, but they kind of languished before the legislature ended its regular session without action on them. So follow the state laws. If you have an opportunity to lobby, get your ducks in a row. I will say telemarketing, it's a minefield, between the federal law, the various states. But there are ways to comply in a manner that allows you to call and text your customers, call and text potential customers, and make sure you're doing it in a compliant manner to limit exposure and set yourself up as well as you can to nip litigations in the bud. An ounce of prevention now will save you a pound of hurt later. So, talk to your compliance attorneys, call me. I'm always happy to talk to you. That's my shameless plug for myself. But I really do believe your best defense is make sure you have good processes in place early on.
Yeah, absolutely. That sounds like great advice, Dan. So, well, I think that's about all the time that we have here today. It's a real pleasure having you as my guest. I want to thank you for your time and the valuable insights that you shared with our audience. Now, if anyone would like to get a hold of you to discuss any of the topics that we covered here, what would be the best way to reach you?
Sure. My office line, and I'm in the office, sadly, more than I'd care to be, is 202-344-4619. Happy to field calls that way, or shoot me an email, D as in Daniel, S as in Scott, Blynn, B as in boy, L-Y, N as in Nancy, N as in Nancy at Venable.com. And we can chat.
Great. Thanks again, Dan. And of course, as always, I want to thank the audience for listening. If you'd like to hear more, please be sure to follow us on Apple, Spotify, or anywhere you listen to your favorite podcasts. If you'd like to listen to a recording of today's program or would like to learn about class action settlement insurance, which effectively transfers the financial risk away from businesses who are actively defending TCPA litigation, please visit our website at www.risksettlements.com, or you can always reach me directly at kevinS@risksettlements.com. Thank you, and until next time.